part of what's causing the, problem with the line today is that there's a few extra handouts today that there have been in the past. So you should all have 4 handouts today. You should have the regular course evaluation. You should have the regular materials for the presentation today. And then there are 2 special handouts today. One of which is a table that WICLA has tried to keep regarding AMA cases that have been decided. So if you see that you've had a case that involved the AMA guides that should be added to that table, please just let me know, and I'll make sure it gets added to the table. We have been able to track over 60 of these cases with various results. As you can see here, what the table tries to do is give you a very quick summary of what the injury was all about, what the ANA rating was in the case, and ultimately what the result of the case is. Please check our work very carefully. Don't take our word for it. If you see something that is of interest to you, please check out the case itself. Especially the current status of the case, because as you know, those things change from day to day. So please don't just rely on that chart to cite the case to an arbitrator or a commissioner, because you may find that it's not exactly what the summary says it is, or even though we've tried to do the best we can, or that the status is not what's listed on that particular sheet. So please check the work. Although we try to be as accurate as possible. And then the 4th handout you have actually leads us into our discussion of the recent ANA guides cases. And what that handout is a 2-pager. It's printed on 1 page, so it's front and back. And these are the proposals for workers' compensation reform that Governor Romer announced earlier this week. So this is Governor Romer's outline of the proposals for workers' compensation reform. As you can see here, one of the proposals is a proposal that we talked about when we talked about the legislative update, which is a causation proposal. There's a traveling employee proposal. There's a fee schedule reduction proposal, which we also predicted when we did the legislative update, so some of our predictions are actually coming true. And then leading us into our discussion of ANA guides cases today, you see that there is a proposal for some reforms through section 8.1b, which is the ANA guides section, involving some language, and you can read the proposal there. I don't think anybody has actually seen the language, other than those of us who maybe are helping draft the language, but I don't think we've seen the language, but we can see what the outline proposes here. The reason why I wanted you to have this is not only because it's important to our practice, of course, but also because it's very interesting to me that Governor Romer, in his own outline, is talking about the impact of section 8.1b on the value of cases. And as you can see here, the study that Governor Romer cites is one that the commission has done. And to quote from the outline here, it says, while complete data on the use of ANA guides since 2011 is not yet available, a study of 20 cases, and WICLA has tracked 60 cases, okay, from the IWCC shows a 12.24% reduction in reports when using the ANA guidelines. With all due respect to the commission, that is a very strangely specific number, 12.24. I think that it's something worth mentioning and something worth remembering. So I'd like to maybe do a little informal survey of people in the audience who are experienced workers' compensation practitioners about a number like a 12.24% reduction. Okay. First of all, how many of you have already dealt with an guides case. I'm presuming pretty much all of us, right? We pretty much all of us dealt with an A&A guides case. We pretty much all of us at least deposed an A&A guides expert. We've at least seen an A&A guides report. We've probably even tried one or more A&A guides cases and maybe even gotten final decisions on some of those cases. So I consider us to be experts in the A&A guides, right? Because we are the ones who are in the trenches dealing with the A&A guides. So let me put this out there for a show of hands. How many of you believe that the use of the A&A guides has resulted in a 12.24% reduction in awards at the Workers' Compensation Commission? Okay. How many of you feel that the use of the A&A guides, and nobody's going to take a snapshot of this, you don't have to worry about raising your hand, but how many of you feel that the use of the A&A guides has resulted in less than a 12.24% reduction in the value of awards? Okay, a few of us, okay? How many of you feel that the A&A guides, the use of the A&A guides has resulted in more than a 12.24% reduction? Okay, I think it pretty clearly the overwhelming majority. Okay, so by a survey of experts, okay, it has now been determined that the use of the A&A guides has resulted in a more than 12.34% reduction in value of awards. And I really don't want to be facetious about it. I think that the cases we're going to look at and the cases in this chart really do provide some evidence of that. So there you go. So I'll get off the soapbox now and I'll begin the presentation. So what we're going to try and do today is talk about several cases that have been decided in October, November, and December of 2014. A&A guides cases decided by the Commission, and then those kinds of cases decided by the Commission in January of 2015. Why to the end of January of 2015? Those were the ones that have been published by the Commission. So for those of you who haven't seen it yet, you can actually go to the Commission website and get the published Commission decisions through January of 2015. As of last year, the Commission started putting Commission decisions right on the Commission website, and you can get that. Some of those decisions are searchable. You can actually search the PDF for keywords. Some are not, and I don't know which ones are which. In fact, the new lawyer in my office, Eric Lopez, actually helped me go through all of these decisions because, as you can imagine, there are hundreds of Commission decisions being decided every month. So, as always, the discussion of the A&A guides begins with Section 8.1b. Everybody by now knows what Section 8.1b, the paragraph we're going to be talking about specifically today is paragraph B of Section 8.1b, because those are the 5 factors that we're going to be discussing. Before we discuss the 5 factors and how they apply to some of the cases that we're going to look at, we have to talk about the Frederick Williams case once again. As you remember, the Frederick Williams case is the first arbitration decision involving the use of the A&A guides. It's been up and down, back and forth to the circuit court, and the current status of the Frederick Williams case is that it was remanded from the circuit court back to the Commission for clarification of the original Commission decision. The Commission decided again that the case was worth 25% loss of use of the arm, with a more detailed analysis of the factors that were used, and the respondent once again reviewed that award, and that case is currently pending before the circuit court. It's been briefed, it's been argued, and the parties are waiting on the decision from the Cook County Circuit Court, which it is my understanding may be only about 30 days away or so. So as far as I can tell, Frederick Williams is the case that is the furthest along in the line of maybe perhaps making it up to the appellate court in terms of how the appellate court is going to look at the interpretation of section 8.1b. So it's an important case for us to keep our eye on, and it's an important case for us to understand how the Workers' Compensation Commission uses the AMA guides and how the commissioners and arbitrators should be weighing the AMA guides. I've given you a couple of sentences that come right out of the commission decision. The remand, the decision on remand from the court, and here's what the commission basically says. Okay, the commission says, it is my understanding, you can correct me if I'm wrong, but it's my understanding that what the commission is saying is that it can weigh the probative value of an AMA guide's determination. That it doesn't just have to take that AMA guide's determination in at face value, and it certainly doesn't have to give that AMA guide's evaluation any particularly weightier substance than it does any of the other factors of section 8.1b. And here are the sentences from that decision on remand that I think say at least something like that. So, for example, we do not agree with the great weight that respondent wants placed on this rating, because to do so would be to disregard the other factors and give them no weight at all. If you remember, in this case, it was one of the first AMA guides impairment ratings that was done, and the arbitrator and the commission criticized how that rating was done. There was some very sophisticated, there was a very sophisticated analysis of that AMA guides rating, and we're going to pick up on some of those types of critiques and comments in some of these other cases. You should also look at this case. By the way, I didn't give it to you in your written materials, but it's going to be on the website, in the NCLE archive, so you can grab the Frederick Williams case if you want to take a look at it. So, any questions about Frederick Williams or where it's at or what's going on with that one? Okay, great. All right, so let's get right into the October cases. I've also tried to list for you the cases where the commission has affirmed an award even when there was no AMA guides impairment rating submitted into evidence by either party. Because as we all know, that's an issue, right? There's that Mark Smart case that is working its way through the system where there's an argument being made that in every case there is a requirement that there be an AMA guides impairment rating. There are at least a few cases every month, a handful of cases every month, where the commission is affirming or modifying up, but at least agreeing with a permanency, a PPE award in a case where neither party has put in an AMA guides decision. And some of those cases are now fine. So some of those cases have now actually gone fine. So there are a bunch of those kinds of cases cited here. There's an interesting case in October, which I didn't give you, but it'll be on the website, this Stephen Hand case, where, as far as I can tell, the dates of injury are before September 1, 2011, and yet the arbitrator and the commission in the case used the 8.1b analysis, So I suppose there's nothing to prevent the commission from using the 8.1b analysis in cases prior to September 1, 2011, and here's a case where that seems to have been done. So, Edna Murphy is another case where there were no AMA guides, but an award by the commission was affirmed. I want to talk a little bit about these last three cases in greater detail. Anthony Jones, Karina Green, and Josh Goshenauer. I've included the Karina Green case in the written materials because I think it's an important case that you should have on this afternoon or tomorrow morning, you're able to download all of these cases right from the Wicklow website. And by the way, I know, and I see you in the room, some of the lawyers who handle these cases are in the room, okay? So speak up, okay? Or risk me calling upon you, okay? So if you're in the room, please, let's hear from you about the cases. So Anthony Jones is a case where the commission modified the arbitrator's decision down from 25% loss of use of the leg to 22.5% loss of use of the leg. So here's a case that you can look at. If, as a respondent, you're looking to modify an arbitrator's decision down and see how the commission uses a rationale to modify the decision down. The commission took no exception to how the arbitrator analyzed the 5 factors of section 8.1 in the Anthony Jones case, but came to a different conclusion regarding the value of the case nonetheless. Interesting to me about the Anthony Jones case, and as far as I can tell, it's the first reported case where I've ever actually seen this. Apparently, in this case, both parties submitted an AMA guidance impairment rating. I don't think I've ever seen that done before, at least in a reported case. So, anybody want to comment about that, about why it was done? All right, well, here's a case where both parties seem to have submitted a AMA guidance impairment rating. So the Torina Clean case is the one that I've given you in the written materials so that you can see it. The Torina Clean case, the commission affirmed the arbitrator's decision, but there's a really great analysis of the 5 factors in that case. So you should take a look at this case if you're still struggling with how the factors are being analyzed. In this particular case, it was Dr. Atlury who did apparently multiple AMA guidance impairment ratings. And the reason that was, from what I can understand, is that this petitioner kept going in and out of MMI, right? You would go to MMI, and then you'd have to have another surgery, and so there'd be a different MMI date. So Dr. Atlury actually had to do multiple AMA impairment ratings. As you can see, it's a pretty comprehensive analysis by the arbitrator of the AMA guides, of the AMA guides analysis. So, and you can see here that because the arbitrator did such a comprehensive analysis, the arbitrator gave considerable weight to that fact. Okay, and you're going to see these words kind of reappearing, every once in a while. Some weight, considerable weight, minimal weight, little weight. Those kinds of analyses are being done by the commission when it comes to the factors. The petitioner's occupation, which, as we all know, is factor 2. Even though the petitioner had changed jobs, since the employer where the accident occurred, the arbitrator reasonably inferred that it would be challenging to the petitioner to engage in the type of factory work that she had been doing for the respondent where she had been hurt. So here's an arbitrator making an inference about how the petitioner's occupation affects the section 8.1b analysis. Age, okay, age. The petitioner in this case was 39 years old at the time of the accident. And I'm going to point out to you a case where the age is going to be determined at a different time, but this one was at the time of the accident. The arbitrator notes that the petitioner may reasonably be expected to live and work with the effects of her injury for a longer period of time than an older individual. So this is one of those cases where the arbitrator said, look, a younger individual is going to have to live with a disability for a longer period of time. Therefore, the disability should be greater than for perhaps an older individual. So that's how that factor got weighed out in this case. Earning capacity, there was really no direct evidence of earning capacity that the arbitrator in this case can actually link up to the injury itself. So here's a case that says that if you're talking about a loss of future earning capacity, which is factor number 4, that there's got to be some linkage to that loss and the original court injury. Factor number 5, evidence of disability corroborated in the treating medical records. What was important to the arbitrator here was that the petitioner had undergone multiple surgeries. She continued to notice limitations, and that those limitations seemed to be in line with the treating doctor's medical records. So, having heard all of that, the arbitrator decided that the petitioner's testimony was credible, that the respondent's impairment rating, even after that word, the respondent's impairment rater thought that the petitioner was being truthful in terms of her responses and treatments. And that was important to the arbitrator in this case. Based on all of those things, it was considered to be a 17.5% loss of use of the person's whole, and of course, it was a shoulder injury, and it's 17.5% loss of the person's whole because of the Will County Forest Preserve as opposed to an arm, which would be the equivalent of 36% or so loss of use of the arm. Okay, so I recommend the Torino-Lean case to you because it's a really nice analysis of the 5 factors, and perhaps even gives us some guidance in how we might want to be writing up proposed decisions for arbitrators using the 5 factors of section 8.1. So any questions about that case? Any comments about it? Yes?
I was just going to say, we just tried another one of those that came down, probably not going to get a field, same response value, same percentages on the AMA, from the same doctor, same award, same everything. So maybe there's a sense of continuity, similar kind of explanation as well. So maybe there's finally some continuity coming from these awards.
And you know what, when the proponents of the AMA guides first put them forward as something that might be included in the Illinois Workers' Compensation Act, that was one of the arguments that was being made, right? That perhaps instead of like really reducing awards, perhaps what the AMA guides was actually going to do was make awards more uniform and maybe make some type of a certain type of rationale running through at each and every case. So that's good to know that maybe it's actually working out that way.
For better or worse, it's nearly identical to that case and explanation of everything. I might have been the same arbitrator, I don't know what it was.
All right. That should be listed on your chart, who the arbitrator was. So, all right, any other questions? Yes?
I just had a question back, let me jump back to Jones. With the both petitioner and respondents AMA,
Yes.
was there a difference in the result, the AMA impairment?
I couldn't tell because all I had available to me in that case was the commission decision. So I didn't have the arbitrator's decision available to me. It was one of those ones where it, since it was modified down, the commission did its own decision. It didn't do like an affirmative act, you know what I mean? So I didn't have the arbitrator's decision. So I'm sorry, I don't know the answer to your question. Anything else? Okay. Gotchenauer is a case that you can certainly look at. Here's a summary of it, but another one of the October cases. So this is a case where the commission, actually modified it up, right? So the commission modified this one up. They modified it up from 17.5% loss of use of the thumb to 25% loss of use of the thumb, although in this case, the petitioner's attorney wanted 35% loss of use of the thumb. Okay, so you talk about the 12.24% reduction in the value of the case. So it's an interesting case actually modifies up the decision of an arbitrator, using the 8.1B analysis. All right, so let's take a quick look at some of the November 2014 cases. Again, a number of cases where, a couple of cases at least where there was no AMA guides offered by either party, in which there was an award of permanency that was in some way agreed to or affirmed by the commission itself. So, here's one of those cases, okay? It happens to be a state of Illinois Menard case, and, so in and of itself, once when you read the title, it's a controversial case. But what's interesting here is that in this case, what the arbitrator actually said was that when neither party puts in an AMA guides, that inactivity is a waiver, right? So there's some argument to be made from this case that it doesn't have to be an affirmative waiver of the AMA guides, that the inactivity of not putting an AMA guides in is taken to be a waiver. So there you go. Menard, and this is a different Menard, this is the petitioner's name, Menard, spelled differently, is an interesting case to look at because the arbitrator in this case, if you look at bullet point number 3, had some issues with the AMA impairment rating found by Dr. Katz, okay? So you're going to see this being repeated over and over again in these AMA guides cases where the arbitrator of the commission actually criticizes how that AMA impairment rating was done. And in this particular case, the particular criticism was that the AMA guides, when you're dealing with cases where you're seeing a loss of range of motion, you're supposed to be doing the measurements on both members, right? So if it's a loss of range of motion in the arm, you're supposed to, as an AMA rater, be doing the measurement on the unaffected arm to compare it. And apparently, Dr. Katz didn't do that to the arbitrator's satisfaction in this case. So that seems to be a valid criticism of an AMA impairment rating if the doctor isn't doing the comparison to the, what is it called, contralateral member or something, right? Okay, so it's an important case to look at for that reason. Camacho is just another one where there was no AMA impairment rating. Stormy Monday is the case that I included in the original materials, and I have to admit the reason I did it was because I love the petitioner's name. Okay, so it would have been much better if it was Stormy Thursday for today, but it's Stormy Monday. So, but really, it's a pretty interesting case because once again, it's a case where there's a very detailed analysis of the 8.1B provisions, the 5 different factors of section 8.1B. In this particular case, the commission affirmed the arbitrator's award of 15% loss of use of the whole person for back surgery. So, as you can see here, Dr. Weiss did the impairment rating, and I believe that Dr. Weiss is doing a lot of these impairment ratings up in the Rockford area lately. So I'm not criticizing in general that particular doctor, okay, but here's a case in which this particular rating seems to have been what the arbitrator calls suspect, okay? So again, you can see that the arbitrators in the commission are actually looking at these ratings. They're trying to determine how the ratings are done. They're trying to determine what the ratings mean, okay? The analysis of the other factors in